count room to the courtroom. Well, that is where things are heading as Nevada right now becomes a center stage really for a legal showdown.
13 Chief Investigator Darcy Spears has been keeping tabs on the current and pending election-related lawsuits. She joins us with a look at where things stand right now.
The Trump campaign and Nevada Republican Party are likely to keep knocking on Nevada courthouse doors as our state is poised to become the king in a legal chess game.
So the Trump campaign hasn't been shy about sort of foreshadowing this stream of lawsuits. And indeed, they started well before Election Day as well.
On election night, in a unanimous vote, the Nevada Supreme Court rejected an emergency appeal by the Trump campaign and state Republican Party that sought to stop counting mail ballots in Clark County. The appeal was from an earlier loss in a lower court where the GOP raised concerns about observing ballot processing and electronic signature verification, with the implication of a potential for fraud.
But unfortunately, for the Trump campaign, there's really no evidence of widespread voter fraud at all, regardless what type of voting mechanism is used, mainly because, among other things, voter fraud is it's a felony, and the return on investment is very low because you would have to risk a felony in order to have an absolutely minuscule chance of changing any outcome, particularly in a presidential election.
This afternoon, the Trump campaign and state GOP asked for an extra week, citing a pending settlement of the case. That after the Clark County registrar agreed to make all tables where the ballot duplication process occurs visible to public observers. If everyone signs off, the appeal will be dismissed. In the meantime, Clark County can continue counting mail ballots. Those postmarked by Election Day that arrive by November 10th must be counted by November 12th. In another lawsuit, the Trump campaign and Nevada GOP sued Clark County to force officials to release records, including copies of every registered voter's signature. That likely indicates a potential challenge over signature matches of what's on file versus on the actual ballot. A district court judge denied that request and said most of the other records requested didn't have to be produced until November 20th, after county officials finish counting votes. Of course, the specter of a recount demand looms large depending on how narrow the margin of votes ultimately is. Recounts are done to confirm accuracy, check for mistakes, and settle fraud claims. The most infamous recount in U.S. history was Bush versus Gore in 2000 in Florida.
But I think it's important to remember that what happened in Florida in 2000 was a very unusual confluence of events that led to a situation where there was a real technical difficulty with the actual mechanics of voting in Florida. And that was coupled with this extremely small difference in the vote counts.
In Nevada, we have no rules that would trigger an automatic recount. The candidate defeated in an initial vote count can ask for a recount if they deposit estimated costs of the effort, and the candidate gets reimbursed if the recount changes the race's outcome. President Trump has threatened to take his election concerns to the United States Supreme Court.
But I think if you couple these wider vote margins with the fact that there isn't this one really solid reason to be concerned with the operation of the electoral system, then I think that it's probably unlikely that anything that would happen in the courts would have the outcome that the Trump campaign is probably looking for.
Legal experts say the way the nation's high court would most likely be involved would be to review a specific challenge to ballots in a tight race in a state that could tip the balance of the election. Nevada, with its 6 electoral votes, could be that state, and the review could stem from last-minute lawsuits challenging the counting process. Darcy Spears, 13 Investigates.